All right, if the attorneys for our next case, Damaris Hedges versus Maureen Hamilton, case number 232995, would come forward. Good morning, Mr. Norton.
Yes, good morning.
As you heard a few minutes ago, Mr. Norton, our typical protocol is 5 minutes for rebuttal. Is that something you would like to reserve, or would you like to just make your way through the whole argument?
Actually, I'd like to reserve rebuttal time. 5 minutes would be sufficient. Good morning, Judge Jay and Harris and Waller. My name is Brian Norton, and I represent Damaris Hedges, who's a disabled person, and this is my guide dog, Neptune. I wanted to start off this case with just saying that there's two issues. There's one concerning the judge's order, which denied Damaris Hedges her right, her restoration of rights, and also there's another issue concerning the admission of certain evidence during the guardianship hearing, which I believe is immaterial and in violation of her rights under the Americans with Disabilities Act and with the Florida Human Relations Act. Anyway, on the issue concerning the improper use of a burden of proof, is that under the statute, it's 744-1095B, I think. It says in restoration of right actions that the person seeking to restore their rights from a guardianship need to go and prove by a preponderance of evidence that she is capable of having her rights restored. The evidence presented at the hearing consisted of an expert functional medical doctor who was appointed by the court to go, and she said that Damaris Hedges, after interviewing her and reviewing her functional abilities, that she was capable of living independently without guardianship. She had functional capabilities of doing so. Now, this came about. The person who did the interview, Tracy Bragg, was appointed by the court out of a list of several people who were functional experts in the area of interviewing and concluding whether or not a disabled person was capable of living independently and had the functional capabilities to go and have her rights restored under the guardianship. Then also, after that testimony was given, we also submitted some records which were admitted in evidence by the court, which were reports, lengthy reports of professionals who were at the Conklin Davis Center for the Visually Impaired. These professionals,
Norton?
yes.
If I could ask you a question, sir.
Sure.
You've already stated on the record the preponderance of the evidence as the standard that was given by the trial court during the hearing.
I misstated. He did not say anything about what standard of proof. All we did at the hearing, he didn't say anything until we got a final order, and in his final order, he said that Damaris Hedges had not proven her case by clear and convincing evidence.
And,
So
clearly, sir,
yes.
that was, and what I was getting to, that was actually written in the final order, clear and convincing evidence.
That's
correct?
exactly right. That's
Okay.
the first time we were aware. We assumed that he was following the statutory direction in a restoration of rights case, that it was that the person, the ward, was required to prove her case by a preponderance of evidence. We
So,
were
Mr.
very
Norton,
yes.
if we find that there was an improper application or application of the wrong standard, it should have been preponderance of the evidence as opposed to clear and convincing evidence, is the proper remedy at that point to remand for the trial court to conduct a hearing and apply the correct standard?
I think the court, probably the remedy would be best to do that. There is a misapplication of the guardianship law in general by this particular court. In the history of the guardianship laws, you have to understand that Olmsted, back in 1999, I believe, stated that they included developmental persons with developmental disabilities to be covered by discrimination laws, and of course the ADA had passed, and then the Florida legislature took all these things into account. The Florida Supreme Court had a committee which was appointed to go and help the legislature fashion proper laws to go and guarantee people who are under guardianship the rights that they might very well deserve, because, you know, guardianship action, the court should use a strict scrutiny in terms of trying to go and analyze whether people's important rights, such as the right to vote, her right to marriage or have an intimate relationship. There's so many rights that are taken away in a guardianship, and the ability to have people make their own individual decisions. So the legislature worked with different bar committees and fashioned a legislative act, and they said that, and I think if the court reads 744.1012, which is a preamble basically, and saying that people really have important rights and that they should be really interpreted to benefit the person, and then use the least restrictive alternative. So to take away somebody's rights, it's a very difficult thing, and the clear and convincing evidence standard applies there to take away somebody's rights. Now, in Florida, which is not in every state, the legislature decided to go and, under 744.1095B, that the legislature decided to allow people to seek restoration of their civil rights, all the ones that were taken away by guardianship, and allowed them to prove that by a lesser standard of proof. And that was directed by the legislature, which that the trial court should have complied with that standard here. Instead, he mistakenly or overlooked, or whatever reason, I have no idea, when he wrote his final order, we were surprised to have him say that Damaris Hedges had not proven her case by clear and convincing evidence standard. And so we were amazed at it. And so we filed for a rehearing, indicating that that's not the proper statutory language. And that was just summarily denied. So that was one of the grounds that we used in filing an appeal. And if the court has any further questions about that, I'd just like to say one thing. It would be clear that if it were not a clear legal argument, than we would have if it was an argument about there was not sufficient competent evidence. If the judge had used the preponderance of evidence standard and he still denied Damaris's restoration of rights, then we would have gotten a transcript. But this is similar to a case where, say, in a criminal case, if it's a bench trial and the court wrote an order saying the prosecution has proven by clear and convincing evidence that the defendant is guilty. You know, it's the wrong standard of proof. It's not a reasonable doubt standard, and that's the only thing we're arguing here. And for that reason, we just don't think a transcript is really necessary. It would be a waste of judicial time and expense. So if there are any questions about that issue, I'd be happy to answer them. The second issue concerns also an error that's pretty fundamental. It's using a test, an IQ test, to go and consider that as a factor in whether or not Damaris Hedges has the functional capability to have her rights restored. Now, if the test was done properly, considering the
Mr.
fact
Norton,
that yes,
you have approximately 10 minutes left on your argument time.
okay, thank you.
We haven't gotten to the 5 minutes yet.
Okay, great. If the test had been done properly, they would have given her extra time. Damaris is blind, and she also has a debilitating disease, multiple sclerosis, I think. And she does have some vision. A lot of people don't know that blindness, the community of blind Floridians, about only 20% are totally blind like I am. The other people have a variety of blindness, a visual disability, but you know, I went through all the stages as I progressively lost my eyesight. But Damaris Hedges, she can even use an iPhone without voiceover, which I use. But she has to hold the phone right about 2 inches from her eyesight. She really is very slow at certain things, and that's why she is capable of lots of things. Like, she's much better at an iPhone than I am. But I don't want to testify here, Your Honor. But I just want to say that if the test had been properly done, if it had given her more time, or if they had gone and taken into account her blindness, given her more time, and also there was no reasonable, for example, now, they didn't give her a reader or more time, and those things could have been easily done when they gave her the test, and the mother knew that they weren't giving her that extra time, and she introduced that as showing her lack of functional capability, and the judge used that because it's, you know, that she on her scale, the Waist Intelligence Scale, which basically compares people of her same age group to her test results, and it came out that it was so low the judge assumed that she was functionally so developmentally disabled that she couldn't take care of herself. But that was contradicted by both the expert Tracy Bragg and by the professionals at the Conklin Davis Center, who she lived there for 3 years, and they thought she was ready to live independently with assistance. The mother did not want her to do that. So now, in terms of accommodations on taking this waste, the Wasserman Adult Intelligence Scale, I believe, and it's used the IQ test, is what it's called. So there was no reasonable accommodations for using that, and that makes it immaterial evidence. It's not really valid evidence, and it's not only not valid to show anything concerning her functional abilities, but it's in violation of the Americans with Disabilities Act and the Florida Human Rights Act. I know that this is just a test that people use, but people don't understand that it does have an impact on results. and that was not taken into account by the judge. For example, when I became blind, I had to go take the Florida bar exam again. The Florida bar gave me extra time, I think 25% extra time to take the test. And then I was able to use my, they gave me a computer with a voice on it, so a screen reader, they call them, and it reads everything, all of the stuff on the screen, so I could do my essay part. But then when I did the multiple choice, the Florida bar said, and this was only a few years ago when I retook the bar, because the first time I had taken it back in 1975 when I was sighted. And when I came up with a multiple choice test, the bar said, it's not blind accessible. So they had the general counsel and the deputy general counsel of the bar, they read the test to me on Zoom. So I spent 5 hours with both the deputy general counsel and the general counsel where they would read the questions and then read the multiple choice answers. It was, but no effort was made to give that type of reasonable accommodation by the testing service, and that's a serious error in terms of just making a decision. Yes.
You have 5 minutes and 5 seconds left.
Okay, well, I'll just come back and answer any questions you may have. Thank you.
Thank you, sir.
Thank you.
Good morning, and may it please the court. I'm attorney Victoria Zinn, here on behalf of the appellee, who is the mother and the guardian of the ward. The issue before the court today is actually quite narrow in scope, and so I'll briefly provide a little bit more of a succinct outline of the facts that led to the instant appeal. The ward is 43 years old. She's diagnosed with Joubert's syndrome, dysthymic disorder, mild mental retardation, cerebral palsy, and she's legally blind. The guardianship began in August of 1999 in Alachua County and was transferred to Volusia County in September of 2020. The mother of the ward has raised, loved, and cared for the ward from birth and became the guardian when the ward turned 18, 25 years ago. The guardian and the mother of the ward has always tried to take a least restrictive means to caring for her daughter. She's helped her obtain employment and helped her in independent living throughout her life.
I don't think anybody on this panel would dispute with you that there are very compelling facts that have been part of this record on appeal.
Yes, Your Honor.
In no way, shape, or form would we minimize those compelling facts. I think the question that we have is the application of the proper standard in the trial court. So would you please speak to that?
Yes, Your Honor.
I believe we need to have, especially in a case such as this, where we're depending and we're asking the trial court to sort out exactly how people are supposed to get through life with significant disabilities, but we need to have a clear application of the proper standard. Would you agree with me that at least on paper, that standard has been confused or has been applied inconsistently from what we've had to look at?
Yes, Your Honor. On the face of the order, the court did apply clear and convincing evidentiary standard versus the preponderance of the evidence standard in Chapter 744.464. However, I believe that the court rectified that when he entered his order denying the petitioner's motion for reconsideration or rehearing. In the petition, or the motion for reconsideration or rehearing, Mr. Norton raised the issue that he felt the proper legal standard was not applied. Judge Clayton, in his order denying that motion, stated that after carefully considering the matters addressed in the motion, the court finds that the motion is a re-argument of the issues fully addressed in the hearings on May the 23rd and on July the 19th, and fully considered by the court prior to the entry of its order. The motion raised no new grounds, nor did it assert anything that the court had overlooked or failed to consider. Your Honor, the court would not have ruled differently under a different standard.
Ms. Zinn, I appreciate that. That sort of begs the question, though, does it not? I mean, the court doesn't say I agree. If the court came back and said, oh, it should have been a preponderance of the evidence standard, I have now applied that and it doesn't change my decision, but that's not what the court said. The court never specifically addressed the argument that was made in the motion for rehearing, other than to say it was just a restatement of what had been said previously. So where in the order you just read does it say, I inadvertently applied the wrong standard in my order, and now applying the correct standard, it's the same result? Is that anything that was said by the court?
No, Your Honor, the court does not specifically state that, but I do believe that his order denying the petitioner's motion does cure the defect by stating that the motion raised no new issue that was previously not presented, and that he had discretion to determine whether the hearing was necessary. As a result, I believe that the court has already considered all of the facts and the evidence presented, and pursuant to Applegate, there was no transcript whereby...
Well, and that's true. I know what Applegate says, and we deal with Applegate all the time. But this is on the face of the order, on the face of the judgment, and Applegate also speaks to, as I know you know, if you've got something on the face of the judgment itself, that is a good enough thing. So is this not on the face of the order, the face of the judgment, where we could consider it without a transcript?
Your Honor, on the face of the order, it does state that he used the clear and convincing evidentiary standard. But again,
which is you would agree that's the incorrect standard?
That is the incorrect standard, Your Honor.
So if, and I believe Judge Wallace rightly asked Mr. Norton, if we are to send it back, do we need a new evidentiary hearing down below, or
no,
not?
Your Honor. The evidence that would be presented at a new evidentiary hearing is identical to the evidence that would have been presented at the prior hearing. It would be heard by the exact same court with the exact same testimony of the ward and of the guardian, the exact same reports, the general intellectual evaluation.
Does it matter if the judge has since retired?
It would be before the same court, so I believe that the court would have to rule similarly to how the judge ruled, other than on its face having miswritten the order. I'd like to point out, however, that...
Well, that's an excellent point by Judge Harris. If we got a different judge, how in the world could a successor judge get in the mind of the initial judge? Wouldn't there have to be a whole new presentation of the evidence? Or am I missing something?
If there were new presentation of the evidence, it would not necessarily result in a different result just because the judge is a different judge.
Not necessarily, but wouldn't you need to give that judge the opportunity to evaluate the evidence and to make his or her own decision based on the evidence?
The new judge could make his or her own decision based on the evidence. However, again, Judge Clayton carefully considered all of the evidence presented before him. Remanding this for a new evidentiary hearing would, in my opinion, be a waste of time and resources as a result of the fact that, again, all of the same exact evidence would be presented before the circuit court.
Well, isn't, and correct me again if I'm wrong, and this is something that happens fairly frequently, where we have to send something back. And it's the same judge, I get it, that the judge that's already heard everything, that judge may then be able to apply the correct standard and to give the answer based on the new standard. But if you have a different judge, in my experience, that's a redo. I mean, that's a hard reset. I mean, all three of us were circuit judges. I had to deal with that. I was on the family bench. And I had to deal with that in a fair number of cases because the other judge was gone, and I had to, in a de novo way, look at the evidence again. But if we don't have the same judge, it seems to this judge there would have to be a whole new evidentiary hearing.
Yes, Your Honor, I understand that position. I'd like to point out that the main evidentiary issue that appellant further argues is that the lower court should not have considered the Wechsler adult intelligence test. That's the primary argument there in determining whether or not the capacity should have been restored. So with regards to that piece of evidence, the report specifically stated, as pointed out by the appellant in his initial brief, that the ward's performance was impacted by the visual impairment. So actually, by considering the report, Judge Clayton strictly adhered to 744.1095, which provides that the ward would be entitled to testimony in various reports in an effort to determine whether or not they'd regain capacity. Appellant is, in essence, asking that the court essentially substitute its judgment for that of the trial court on a matter that was well within the court's discretion. It's clear on its face that Judge Clayton did pointedly and meticulously consider all of the relevant evidence as evidenced by his order denying the motion for rehearing, and therefore the order under review should be affirmed. If there's no further questions, I'll rely on the brief.
Thank you. Mr. Norton? Take your time. Mr. Norton, according to the clock, you have 4 minutes and 59 seconds left.
That's plenty of time, thank you. Your Honor, when we had the hearing, I have to admit, I am not an experienced guardianship attorney, but I did this to represent her. I did, prior to going and coming to court to have this hearing, I tried to negotiate with the mother, who obviously loves her daughter, but is very protective and doesn't want to let go. There would be, at the hearing, there would be new evidence presented in front of whatever judge is assigned to the case, because when we went to hearing on the restoration of her rights, I first of all had no idea that the court would use the incorrect standard burden of proof, but we had at that time, the only thing we knew was that the judge had appointed a medical examiner to go and give an opinion, and we were given that, saying that her rights should be restored. We had also the records, which were admitted into evidence without objection, of the great progress that Damaris Hedges had made during her several years of residential living at a training facility to go overcome her problems. The mother brought up all these things that happened before that training, anticipated, but she lived at the Conklin Davis Center. They helped her learn new things to help her get her rights restored, which is really what the guardianship statute really wants people who are under guardianship to go and to get educated, to become independent and self-functioning, well-functioning Floridians, and that's what the restoration of rights is, a lower standard of proof than the clear and convincing evidence standard to go and make that. And then unfortunately the trial court had one hearing when the mother, she saw that the evidence was against her with the expert witnesses and the professional evaluators at the Conklin Davis Center, and she asked the judge if she could get another expert to give another opinion. She did not like the expert opinion that was presented by the court. She thought that was wrong, so the judge said, okay, he gave her 6 weeks to have an opportunity to get another expert witness. And of course, the judge, we had the list that the court had given us of like 6 expert witnesses who had that expertise in this area, functional abilities, and she could have chosen from that list, but instead she just went to this business that does IQ tests, and then when the judge got the IQ test back with the results that she had a developmental disability, very low IQ, and the judge just assumed that she could not take care of herself. Unfortunately, that's a prevailing standard among a lot of Americans, that disabled people can't be trained to overcome their disability. I quit working as a lawyer because when I went totally blind, and then I went back to school again. It took me It took me going to school for the blind here. I had to go to paralegal school again, and finally they talked me into taking the Florida bar exam, and I passed that. But I wouldn't have been able to do it at training, and training is important, yes.
I believe from my review of the record that the last time a judge saw your client would have been roughly July of last year. Is that correct?
That's correct.
So since then, there's been no circuit judge to have your client present to be able to evaluate, even just visually, the condition of your client. Is that correct?
No, Your Honor. And besides that, the mother, once the Conklin Davis Center, it said that she can go to have her own apartment with assistance from the Conklin Davis Center. The mother took her home, and she's been at home isolated with no, under the complete guardianship of her mother. Since that time, she even interfered. I filed a motion because she was interfering with me ever meeting with my client. She's been isolated since that time with no, and that's where the mother will probably keep her if she's not allowed to have a proper restoration hearing. And yes.
Mr. Norton, thank you for answering Mr. Wallace or Judge Wallace's question. You're through your rebuttal time, but I will give you another 30 seconds just to summarize your argument before we finish.
Your Honor, I think that Damaris Hedges, if she had a proper hearing and the judge went through expert opinions and relied upon professionals who know something about it and had an opportunity to go and show what things she's capable of doing and did a proper analysis and give it a written opinion. We don't have the benefit of any type of opinion about all the things that she can do and what she doesn't have done. She could have, then the trial court might decide that she needs some assistance, or maybe she could live independently. We don't know, because there really was no real proper hearing, and I think that a new hearing would give us an opportunity to go and find out whether she can have her full rights restored and the guardianship eliminated, or have some type of limitations.
Thank you, Mr. Norton.
Yeah.
Thank you both for your fine presentations. We take your time again, Mr. Norton.
Okay, thank you very much.
Ladies and gentlemen, we will be in recess. It looks like it's about 12 after 11. Why don't we plan to come back for our final case at 11:20? We'll be in recess until then.
All right.